So hello everyone, I hope you're doing fine. As I've promised, in this episode, in this video, we're gonna talk about the civil court procedure of the law of tort and the award of damages, financial compensation by civil court to the claimant. I want to sort everything out in this video in your minds. I don't want you to have any questions. I want everything to be crystal clear. So let's begin. Let's begin to tackle this puzzle. So I'm the claimant, let's say, and I've suffered damage by person A, and I am person B. I go to the court, I take a claim form, and I file the claim form so as to seek compensation and go to court. But where exactly does, let's say that, and the path is set, but where exactly does my case begin? The answer is that my case will begin at the court of first instance, which will normally be a county court, or in some special circumstances, in some special cases, it will be the high court. If the defendant appeals, then we're going to go to the Court of Appeal, the Civil Division, and the final appeal will be the House of Lords. It must be noted that it is up to the claimant to prove beyond any reasonable doubt on the balance of probabilities that the defendant has caused him the suffering. So the burden of proof is on the claimant. Let's continue. What exactly and specifically is the procedure? So I am the claimant. I take the claim form. I file the claim form. Then what does it happen? Well, then the court will send to the defendant the claim form which I have submitted and a defense pack. What does the defense pack include? Well, the defense pack will include a defense form where the defendant will reject all the accusations and will prepare his defense, an admissions form where he will accept or partially accept the accusations, and another form where he will notice the court that he has received the information. He must be noted again that the defendant will only have 14 days in order to complete these forms and file them to the court. If he fails to do such a thing, the court will rule without his presence, and the court may rule against him. So, if he files the defense form within 14 days, the claimant will receive the defense, and both parties, the defendant and the claimant, will receive an allocation questionnaire. What the hell is this allocation questionnaire? Well, it is a very practical thing. It is more for the organization of the civil procedure, and its task is to organize the timing, the place where the trial will take place, and the track of the case. You're wondering, what is this track? Well, I must make clear to you that there are three specific tracks which aim to smoothen out the civil court procedure. There is the small claims track, the fast track, and the multi-cause track. The fast track, the small claims track is for claims below £5,000. The fast track is for claims above £5,000 up to £15,000, and the other one is for claims above £15,000. So I believe that we have sorted everything out in your minds regarding the procedure. And as I've mentioned before, the burden of proof is on the defendant. But you will be wondering, are there any exceptions? Obviously there are exceptions, and it is the exception of the res ipsa loquitur, which means that the thing speaks of itself. It is a special circumstance where the situation is clear and that the claimant does not need to prove that the defendant has caused him the injury and the loss. And there are three elements that need to be satisfied in order for res ipsa loquitur to exist. And these are that the defendant has complete control over the action that has caused the damage to the claimant. The damage and the injury that has been caused has been caused because someone has been negligent. So someone needs to be negligent in order for such a damage to be caused. And also, there is no other explanation for the cause of such a damage. So if we have these three elements, res ipsa loquitur exists, and the burden of proof is no longer on the claimant. The case is clear and straightforward. Okay, we've cleared that out, we cleared the civil court procedure, and now let's just clear the most important part for the claimant: money, compensation, financial compensation. Damages. There are two types of damages: special damages and general damages. Special damages are those damages, financial damages, that they're quantifiable and that have occurred up to the point of the trial. Maybe their medical expenses, maybe I've been hit by, my car has been hit by the defendant's car, and my car needs to be fixed, so it's material losses. So generally you got the point, is that all the financial losses, financial costs that I have incurred up to the point of the trial. And we've got general damages. What are general damages? General damages are damages that do not have a quantifiable sense. They cannot be quantified. There are three specific categories of these types of damages. It is the loss of future earnings, it is the loss of amenity, pain and suffering, and it is the need for future medical care and personal assistance. So that it is for damages, very synoptically, with a very, very basic grasp. I believe you got it. You got a very basic grasp of what are damages. And the only thing that is left for you to understand about tort, so you can get an idea generally of the concept, is how is the financial compensation going to be paid to the claimant. Well, it can be paid in a lump sum, or it can even be paid periodically, monthly, let's say, or it can be a part can be paid and then the rest can be spread over several months, and it can be paid periodically. So guys, folks, this is it. I believe it is straightforward. Hope you understand it. Hope that I was of help to you. Thank you so much. Stay tuned, and in our next episode we're gonna analyze the law of contracts. Contract law. Excellent. Thank you. Have fun.